Spaceship has landed, and that is true logic. All right, so today I'm going to talk about this new South Dakota law that requires all public schools to hang the words, "In God We Trust," somewhere visibly inside of their buildings, right? It must be stenciled, painted, or otherwise prominently displayed, and according to this law, it must be at least 12 by 12 inches in font. For sources, this is via Business Insider. That's where I'm getting the source of this information from, right? Also, according to them, at least 10 other states have passed similar laws this year regarding their public schools, the state of Kentucky being one of them, right? South Dakota Senator Phil Jensen, one of the sponsors of the law, was quoted by Business Insider as saying, "This is a nation that trusts God," right? He also stated that this was about returning to the values this country was founded on. However, Business Insider notes that many of the students of South Dakota have protested against this law that just went into effect, right? The primary question we're trying to answer today is whether or not this law, which requires all public schools in the state of South Dakota to post the words, "In God We Trust," somewhere visibly inside of their buildings, is a violation of the freedom of religion, right? In order to answer this question, though, we must first define what freedom of religion means, right? And I'm going to do this by highlighting the constitutional basis for freedom of religion and subsequently how the Supreme Court of the United States has historically interpreted this part of the Constitution, right? One, the First Amendment is the amendment that addresses religion, and it has two clauses that focus on the freedom of religion. The first of which is the Establishment Clause, which states that the government shall not establish a religion. Traditionally, this means that no state-sponsored churches, beliefs, religious rituals, etc., right? Then finally, there's the Free Exercise Clause, which obviously allows for the free exercise of any religious practice so long as it does not ruin public morale or hinder any critical government interest, right? Some major Supreme Court decisions on this have been Engel v. Vitale, which I don't even know if I'm saying that correctly, but this is a major Supreme Court decision that occurred in the year 1962, right? In this 6-1 decision, the Supreme Court ruled that it is unconstitutional for states to require students to read the Pledge of Allegiance out loud each day because the purpose of the First Amendment is to prevent all government interference in religious matters. This is via uscourts.gov for those of you that are interested in sources of information and would like to do some research on your own, right? Another primary Supreme Court decision following the 1962 decision of Engel v. Vitale is Santa Fe Independent School District versus Doe, which I believe occurred in the year 2002 or something like that, but you'll have to double check that for me. Forgive me if that date is incorrect, right? In this 6-3 decision, the Supreme Court upheld that it was a violation of the Establishment Clause for a school to allow student-led prayer on the loudspeaker of sporting events. This is via oyez.com. That's oyez.org, actually, not .com, oyez.org, oyez.org, right? In this decision, the court concluded that the football game prayers were public speech because they were authorized by a government policy taking place on government property at a government-sponsored school-related event, and that the district's policy involved both perceived and actual government endorsement of the delivery of prayer at an important school events, right? Such speech could not properly be characterized as private subsequently. And this is from the majority decision that was written in that case by Justice Stevens. So, based on this argument and this historical basis from the Constitution in previous Supreme Court decisions, it would seem that this law by South Dakota requiring all public schools to hang the words "In God We Trust" visibly is definitely a violation of the freedom of religion of the First Amendment, right? Recall, as I stated earlier, that South Dakota Senator Phil Jensen himself stated that at least a major part of the purpose of this law is to return the nation to its founding values and principles, right? The primary issue with this, however, is that the country was founded by Christian denominations, right? So to say that this law is about returning to those values is essentially to outright admit this law is supporting specifically Christian religious ideals, right? This is a clear example of state-sponsored support for a particular religion and therefore seems to directly contradict the Establishment Clause, right? Furthermore, recall the argument in the majority decision of Santa Fe Independent School District versus Doe, right? The Supreme Court decided that part of the issue was that it was a government-sponsored event. Obviously, all public schools are government-sponsored, right? Hence why they're called public schools, right? So this law very similarly uses government-sponsored resources on government-sponsored and controlled land to promote the agenda and ideas of a specific religion, right? Now, while I am no legal expert, this certainly seems to me like a direct violation of the Establishment Clause, right? And we might also examine what freedom of religion means from a philosophical basis, right? Recall that a lot of the ideas that went into the Declaration of Independence and went into the U.S. Constitution were ideas that had been previously formulated during the Enlightenment period by many Enlightenment philosophers who were challenging the status quo of monarchies and kings and those types of rules in Europe, right? Two prominent Enlightenment philosophers being John Locke and Jean-Jacques Rousseau, right? I believe John Locke is Irish or something like that, I forget, but Jean-Jacques Rousseau, if you can tell by the name, was a French philosopher, right? And both of these philosophers of the Enlightenment period argued against the government's interference in religious matters, right? Rousseau, agreeing with Locke, in his book The Social Contract, argues that religion is a private matter that should not involve the state, right? He also asserts the importance of tolerance in a pluralistic system. One who expects his or her religion to be tolerated must also be tolerant of the religions of others. And my sources on the philosophies of Locke and Rousseau come from the Stanford Encyclopedia of Philosophy, for those of you that are interested in doing more research on these two philosophers yourself, right? So, on a fundamental level, the core question here is, to what extent does a sovereign government operating in a democratic system have the right to interfere with the private beliefs of its citizens, right? Here, the word interfere has both direct and indirect interpretations. Firstly, interference could mean the direct implementation of laws which prohibit a particular religion. Now, obviously, this is not the case in the South Dakota situation. However, right, by promoting the phrase, "In God We Trust," the state of South Dakota is directly promoting one religion over another, and subsequently is de facto denying fair and open practice in support of other religions, right? Rhetoric of space is a critical thing here, right? Both Locke and Rousseau agree that pluralism is an essential aspect of American democracy, or democratic systems altogether, though they refer to them as social contract governments, right? The idea being there that you as an individual give up certain particular rights of your individuality in order to form a social contract in which you can peacefully coexist with certain rights with other individuals, right? Pluralism is the idea that there are many types of truth and not only one single grand truth that all must follow, believe, obey, etc. Right? However, as noted, the state's open embrace of Christianity is a direct denial of pluralistic views, right? It is a way of saying there is a single God that is trusted and upheld by the state, right? Hence the words of Senator Phil Jensen saying, this is a nation that trusts God, right? One God, plural. He's clearly speaking about Christianity. He's clearly speaking monotheistically when he makes that statement, right? Now, the state is typically seen as the ultimate authority in regards to legitimacy. That is, the government is the only entity with the universally recognized right to lawmaking, right? And the laws of a society subsequently foster specific normative values about what beliefs, behaviors, etc. are acceptable and unacceptable within a society, right? Something is taboo only insofar as it is contradictory of normative value and subsequently the values on which the law is founded. So, anything supported by the government is established as legitimate, while anything outside of this is subsequently illegitimate under that conceptualization of normative values that are created by the law, right? Therefore, by hanging the phrase, "In God we trust," the state of South Dakota is using government legitimacy and power to directly delegitimize all non-Christian religions and denominations, right? Freedom of religion, however, is supposed to be about the open practice of many religions, not a particular religion, right? Now, one of the counterpoints here that one might argue is that the phrase is already on our currency, so why not just allow it in public schools? Now, I do have my objections to it being on currency, and that's certainly for the same reasons that I object to this being hung so freely in public schools across the nation, right? Because it's the governments of those states directly offering support for a particular religion, right? Using their power and legitimacy as government institutions to subsequently delegitimize the ideals of other religions. And that is true logic.